Good morning, Laura. Oh, I'm sorry, I can't hear you. Hold on a second. Hi, Laura, now. I'm
There you
sorry. I could not hear you.
Okay, I forgot to ask Kim how many people were registered. Let me go ask her real quick. I'll be right back. Okay, so everybody is here. All righty. Whoop. Come on, Neela, let me see your face. You too, Ryan, Ariel, Allison. I don't like talking to black boxes. You guys know that. All righty. Give it a couple. All right, you guys ready to go? I asked a question. You guys ready to go? I think I heard somebody.
Yeah, I'm ready. Sorry, my wife is on a meeting right now as well. We're both doing Zoom.
Okay. Let your guests know that I'm stopping by after work today. Okay, so let's get going. I'm going to share the screen. These are the new forms that are some of the new forms. This is not all of them. This is some of the new forms that are being released on June 20th. I'm moving around some screens to get stuff out of the way. There we go. That's better. Now I can see you guys. Much, much better. It helps when I can see who I'm talking to. I feel better. Okay, so can you guys see the form? Why does it turn blue?
Yes, I see.
I don't know why it turns blue like that. Can somebody tell me?
I think you highlighted the page.
Yeah, I think you all selected it. So you just click it one more time to unselect it.
Okay. Oh, jeez. Click it one more time. Oh, okay, there we go. See, and that's why I need you guys, because I'm terrible at this stuff. How do I get it to run the people to run down the side? Yeah. There we go. That way I can see you guys. Awesome. The only one who's not camera shy is Nina. Come on, you guys. Allison, Ryan, Ariel, Long. There we go.
Hey, Laura,
you.
I'm actually preparing to leave. I have an appointment, but I'll do what I can
Okay, sounds
to keep
good.
up. Yeah,
Okay, so as
thank
I
you.
said, these are some of the forms. They're either new or being released on June 20th. So the first one, as you see, and this is new. This is a seller. This is the commercial seller property questionnaire. So this is the commercial SPQ, which is new. We've never had this before. So, and it explains to you here that it's not required for the transaction, the TDS. And this is actually not required, but we will probably require it within our office, but it's not legally required by the DRE. And there's some notes here. It is to provide information. And my favorite notation on here is seller's disclosures are not a substitute for your own investigations, personal judgments, or common sense. Love that wording. So, and then what this does is that this is to make it easier when you're dealing with a commercial property to learn more about the property, because what might not mean anything to you as a seller, as the buyer, it may mean a lot. And this is why they came up with this, because there's always questions about permits and modifications, just like the SPQ. And that's why it's also important to have this. Disaster release, water related stuff. So, and as with the SPQ, it's stating here that a yes answer is appropriate no matter how long ago the item being asked about or was documented. Okay, so that means, and this is going to spill over eventually to the TDS, to the SPQ. I think they may have changed it on the SPQ, because, like, for instance, if you were selling the commercial building that ESL was in, you would want to know that there was a mass murder in that building. That if you were the buyer, that may be very significant to you. So it doesn't make any, and that happened 30 years ago. So it doesn't make any difference if it happened 30 years ago or yesterday. If you know that something happened, you need to divulge it. And so we're talking about permits. And again, any yes, please, they want you to put in an explanation. And this is one of the things, like permits. Okay, you put yes, you might want to put in here, remodeled the bathrooms or the offices with permits. And you have copies of the permits to give. They have statutory things required, whether the property was built prior to January 1st, 1994, because this is compliant with the plumbing fixtures. So this is really very similar to the SPQ. It's just the commercial version of it, asking things that are people in commercial are also interested in. Water intrusion, because a lot of commercial buildings tend to be in the central part of the San Jose, Milpitas, and around that area. One of the issues is that parts of that area are below sea level, and there are water issues in that area. Same with the housing in the area. If you're over, for instance, the buildings that are off of 237 and 101, that area has a very, very high water table. And both the commercial and residential tend to have problems, depending on where they are, tend to have problems with foundation problems, because they tend to crack because it has such a high water table. And again, it's going through, the hazardous zones in substances. This is very important in commercial, talking about boundaries, landscaping. But I just want you to know that this is there. Excuse me. I want you to know it's there. Now see, I'm getting a message. Okay, I know you can see it. So if you run into commercial, you know that this is going to be a new requirement within our office for the SBQ. And it's a 5-pager. It's pretty comprehensive. Okay, the next form, the designated electronic delivery address amendment. If you remember correctly, on page 16 of the RPA and the real estate broker section, you were putting your information. You're putting in the brokerage, you're putting in your name, and one of the things that they ask you to fill out is your email address. And this is no longer optional. You need to put in an email address. And if you don't, you need to fill this form out. And the email addresses, we need that because that is tied in with the new definition of the terminology delivered. Because remember, according to the RPA, the new definition of delivered means if I send a document to the email address that is on the RPA, page 16 in the real estate broker section, it is considered, as soon as I hit that button send, it's considered delivered. So email addresses are very important. If you leave it off, or if you're on the other end, if you're the listing agent and the buyer's agent does not give you that information, personally, I would send them this and to ask them to fill it out, because that is vital. Because if, for instance, if you have a counter offer that you sent out as a listing agent, you send out the counter offer and you want to know that they have received the counter. And if you're on the buyer's end, because of this, if you send in the acceptance of the counter offer, you have validation via the email that you sent it within the appropriate amount of time that was requested for it to be valid. That's why this is critical that you fill it out, because the email addresses can determine if something was delivered or not. Any questions on that? You guys remember the RPA page 16? Wake up, Long.
Yes.
I'm all listening. Just my hair.
Okay.
Yeah, it's tripping me.
Okay, this is another new form, which this form will be automatically propagated when you when you bring in the RPA in zip forms. It's automatically populated. This is a new requirement, and this is to in alignment with court decisions about appraisals. And because there was issues, and not really so much in the Bay Area, but outside of the Bay Area, this is coming down from NAR. This is there was a trend in cases where they proved that appraisers were making decisions based on categories that are protected by law. For instance, as it says in here, gender identity. It could be race. It could be the language used. That for whatever reason, they were giving lower appraisals than they would have if that circumstance had not existed. And this gives the buyer and the seller the opportunity to challenge them on an appraisal if they believe that the discrimination laws are being violated, the fair housing laws. And it's very clear in here that that the buyer or seller is claiming that they felt that the appraisal was influenced by one of the factors that is named in the paragraph above. It also informs them to, send the information to the lender or the mortgage broker. And it also gives you the ability to file a complaint against that specific appraiser. And you can actually call it in. So this is giving you more power, because there are times when, for instance, and I've seen it myself, that an appraisal will come in like $150,000, $200,000 short. We pull the comps and we're like, what's with this? Because it just doesn't make any sense. And one could say that they feel that the appraisal was biased. So this gives you the opportunity to clear that up. This is brand new. And again, this is going to be auto-populated. This is another new form, and this is for mixed use purchases. For instance, not too long ago, Mark Zhang bought his clients a property. Downstairs was retail, upstairs was residential. And at that time, we didn't, we kind of like mixing commercial and residential forms to get everything all qualified and everything. So this tells you that now that there is, for instance, like right here, that there are commercial units, how many? And are they going to be delivered vacant? You describe up here, you're describing the mix, how many residential units, how many commercial units, and you give a quick description. You might want to say that there's, the residential units, you have 4 2-bedroom, 1-bath units. And the commercial side, you have a barbershop, a pet store, and something else, or restaurant maybe. But you can, this way you can describe what the mixed use is. Now, items included. Now, this is important, especially on the commercial side, on the items, because in here it says a complete inventory of all personal property of the seller currently used in operation of the property and included in the purchase price shall be delivered to the buyer within time specified in paragraph 3 and in the agreement. And what they're talking about is, for instance, say one of the commercial units is a hair salon. So the hair salon, they have all the tables, they have all the chairs, they have the front desk and all of the furniture that belongs to the office. But they may be selling that furniture, whoever, say that the owner of the building is the owner of the hair salon, and they're saying, okay, you're going to be putting another hair salon in here, or I'm staying here, I'm going to be leasing this property from you now, and all of my personal inventory is going to be included in the sale, and it's now yours. Because those chairs belong to the business. The front desk belongs to the business. And what this is saying is that they're using this, the sinks that they had put in and stuff like that, those belong to the business. So you have to be able to determine what's being left and included in the sale. And it has to be very clear. And the seller has to deliver title to the personal property by a bill of sale because it's personal property. Also, as an addition, as it's stating here, as another security for any note in favor of the seller for any part of the purchase price, the buyer shall execute this form financing statement to be filed with the Secretary of State. So this is all brand new. This is mixed use. So this is things you need to get used to. Additional allocations of cost. Who's going to be paying for the phase 1 environmental survey? This is commercial. So in commercial, everything in the world is negotiable. You know, it's just, and it all depends on who wrote the contract. So these are things that you have to be aware of. So this is one of the new contracts. Rental agreements. You know, when you have a commercial rental agreement, you have to make sure that everything is being transferred over to the new owner. So they need a copy of all the leases and the rental agreements. They need statements. Actually, some people actually ask to see the seller's Schedule E, which is their taxes from their tax returns. They need income and expense statements. How much money has been spent on the building, on the structure, and the upkeep of the structure over the last year? Estoppels from the tenants. This is a big issue because remember, again, this is mixed use. That means there's residential involved. And in residential, security deposits is a huge thing. In fact, I would say probably half of the small claims court cases involving rentals involves the security deposit. So you need to make sure that there is that the security deposits are transferred to the new owner, and you need to have a paper trail of this, and you need to notify the tenants. This is your security deposit has been transferred to the new buyer or to the new owner. So be very careful of that because that is like a lawsuit waiting to happen. Any questions so far? No? Anybody falling asleep yet? Wake up.
Laura,
Yeah.
Allison here. Yeah, so this is going to be recorded and we can retrieve the recording, right?
Yeah, yeah.
Okay, all right, thank you.
Yeah. And I'm happy to tell you, we were ahead of the curve because remember just like 2 months ago, we created a non-standards forum advisory for our inner office. And now the state of California has come out with that advisory. Yay. Because the use of a non-standard forms, it's first of all, it's very common in new builds like, you know, KB and Lennar, they all have their own contracts. And however, companies like the branch of Zillow that's doing the resales, and there's some brokerages that are actually, they were founded outside of the state of California. They're using their own forms. And we're not attorneys. We don't know what, you know, some of the bugaboos are. And actually they name some of them in here. And then this is advising your buyer if they're in a residential situation, the advantages of using standard forms, because those forms you guys know, and they're blessed by the state of California, or they're blessed by the local association like PRDS that was created by Silvar. Okay, and here are some of the issues that we run across is in the non-standard forms, waiver of statutory rights created by California, even if not permitted under the applicable law. Because remember, a lot of times these contracts are being written by attorneys outside of the state of California, and they do not know California real estate law. So you have to watch for that. Blanket automatic waivers of all contingencies. I have seen this. Also, I've seen C, applying a passive or automatic contingency removal method to the transaction, regardless of other documents in the transactions. And what this is talking about is, say you have in the contract, in our contract, the seller has 7 days to produce documents. And there is a contingency based on the documents. Well, if they don't produce them, according to the builder's contract, even if they haven't given it to you, when you hit the deadline to release contingency, it is automatically released. You have to actively not release it. If you don't, it will automatically be released. And like in the state of California, there are, we have, the inspections. Well, it's based on, your ability to go through the inspection documents and everything. Maybe you gave yourself 7 days. Well, you didn't get all of them. Tough luck. 7 days pass, boom, it's released. The contingency is gone. Providing for non-refundable or automatic release of deposits regardless of fault. So say your buyer went in and they put $60,000 down and they've moved it into escrow. And then later on that day, your buyer says, no, I'm backing out. I don't want to do this. Well, the money could have already been released to the builder. You don't know that. Another one I ran across from one of our, actually it was one of our own agents. She asked me to take a look at the contract that she had already signed. And first of all, they had the passive release of the contingencies, but they also had a paragraph in there that said, oh, well, all of the things that we said we're going to fix, if we don't get those done by the close of escrow, tough luck. So this is why this is important, that your buyers understand that right here, your real estate licensee cannot advise you on legal and practical implications of non-standard forms. They need to be aware. And in many cases, you may want to have an attorney look over the contract to figure out what you're really signing, because I can guarantee you that probably 70% of the people who are signing contracts that are non-standard have not read through the entire contract. And they may be in for some very serious surprises. So please, 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 if you come up against non-standard forms, please have your client sign this to relieve you of any liability, because you don't want them coming back and blaming you because you didn't tell them. Well, you should have read this. You should know this. Well, no, no, I didn't know. Okay, changed forms. Additional buyer broker form. This is a good one. Let me see if because I wrote myself some notes on this stuff. Okay, well, they kind of changed it around a little bit. It's basically the same thing, but if applicable for property described, because it could be for a buyer broker representation that they're signing the addition of the ABA. If it is a purchase agreement or a listing agreement, then you need to put in the property address. Okay, in here they're talking about the purchase agreement or another. Check only one box. Multiple brokers representing the seller, multiple brokers representing the buyer. So you got to check the appropriate box. Also, activity on the licensed broker or the broker or both, as applicable, can be conducted by multiple association licensees, partners, or teams, as indicated in the AAA. So if you check this box, a lot of times you're a team. So you want to make sure that they understand that. And now it must be signed by me. I have to see these. It's okay. Cancellation of the contract. They finally came to the reality that our world has changed. And they have added in a new item and also clarified that the property is a dwelling of no more than no more than 4 units, which one of which the buyer intends to occupy. They also added this here because we now have a lot of times there's been cancellation and there's no money in escrow. And this has become kind of quasi common because of the zero contingency issues. So now you have the option to check this box. Fair Housing and Discrimination Advisory, we all know this one pretty well. They have genetic information. I'm going to get clarified. I have a meeting that I'm going to that I'm not sure what they mean by genetic information. That is a new category. I don't, so we got to figure that one out. But it gives you, it has more clarity to it and it's a little bit more organized. And they grouped things together like sex, sexual orientation's been grouped together, gender identity, gender expression. Those have been grouped together. And they also put in this little caveat that says other classes, categories, or restrictions may also apply. So we got to wait and see what that means. And who is required to comply? They've now added appraisers. Okay, here's our wonderful fire hardening and defensive space disclosure and addendum that everybody hates because it is just clear as mud. You half the time you don't even know what you're looking for and how to make a decision. Okay, the good news is that they are coming out with a new form, which is a decision chart that will help you decide what you're going to be filling out on this. However, it was not ready. It's not ready yet. So I made one up for you guys that makes it a little bit easier. It's a little checklist for you. And it says for the home fire hardening disclosure, if you answer no, we should say, if the answer is no, seller does not have to answer questions in 2B. And it should say, if you answer any of them, no. I'll have to correct that. If the answer is no for any of them, then you don't. And the same with defensible space compliance. If any answer is no, seller does not have to answer the questions of paragraphs 3A, 3B, and 3C. I think this makes it.
Laura, hi.
Yeah.
I'm confused. You're saying in 1A, seller required to complete TDS. And then you say if the answer is no, seller does not have to answer questions in paragraph 2B. Well,
Yep.
the seller, I don't understand that. Seller's always having to
No, they
complete
don't.
the TDS.
Not if it's probate or an REO.
Oh, yeah, you're right. Okay, I see what you're saying. All right.
Right.
Okay, thank you for clarifying that.
Oh, that's a good question. That was
Yeah.
a good question.
Appreciate
I went through this and because the chart's not ready yet. It's going to be coming out and supposedly it's going to be automatically populated for decisions, because this makes it clearer the way they have it. I don't know why they didn't do this right on the form.
Because they're attorneys, they're not very logical. But you might
I didn't say
put
that.
in,
I didn't
I
say
don't know if I'm the only one that was confused on this, you might put in parentheses, exempt, probate, other exemptions to the filling out the TDS might
I'm sure
clarify
that
that.
like I said, the real form is the new decision charts coming out by the 20th. So, but this is just in the interim, and this kind of help you decide if you're really, because
That's very
it's
helpful.
still
Where do
confusing.
we find this?
Pardon?
Where do we find this?
It's all coming out on July.
I mean,
June
where do we
20th.
find your little chart? I just took a picture of it, but is that chart posted somewhere?
It's in the handout if you pre-registered
Oh.
for the class. I can send it to you, Barbara.
Thank you.
Okay, and again, they've restructured the paragraph. So what's written in here is what you see above in the decision chart to make it a little bit easier for you to figure out if you have to complete this form. And they also added, are you, the seller, aware? Because wording was not in there before, and it was very confusing. Well, how do I know? I mean, people were freaking out because the sellers are going, I don't know any of this shit. What are you talking about? And they were panicking. And so they made it clear. It's, are you aware? Well, if you don't know, the answer is no. Simple as that. It takes away a lot of the stress and whatever that word is. Wasn't clear. And again, they've restructured. And see how they put the yes, no questions over here? Makes it easier for you. And they've restructured the defensible space disclosure and addendum. Now, I want to emphasize that you see here that it says defensive and addendum, which means the buyer, this is an agreement. Okay, this is not, take it or leave it. This is an agreement. The buyer and seller have to come into an agreement. And it states so right here, buyer and seller agreement regarding which party shall obtain compliance with applicable state or local defensible space requirements. Oh, before I forget, up here, see, it says defensible space decision tree. This is the form that's going to be appended where you make the decisions like what I had put up above. Are there any questions on that?
Laura, is it negotiable then who pays for compliance, or is it typically the seller who pays for compliance? Okay.
Yeah, it's right here. Buyer responsibility, seller responsibility. So you're going to be checking one of these boxes. And so it has to be, they have to be in agreement. The seller has the right, say the seller says the buyer's responsible for everything. Well, the buyer has the right to come back and say, nope, here's a counter because you're going to do it. Which is, and did I miss something? I thought I'm sorry, I missed this. Okay, because there's always the issue. And some of the NHDs have not caught up with the new law, which I don't know why, because it's not just very high, it's also high fire hazard zones, okay? And here is a website that you can go in and you can put the address of the property in to see where, if it's in or out. This is by the state. This is for the state of California. The interesting thing is, and we've had, because some of you may or may not know that twice a month we have a statewide broker meeting. And somebody was bringing up that their house was not in the high fire zone. The house next door was. So how they figure that one out, don't know. But it gives you a website where you can go look.
So Laura, you're saying that we can't really trust the NHD reports to be accurate. Are there any particular NHD reports you're aware of that have not caught up?
I don't know which ones exactly, but I've noticed that a lot of them do not. If you look at their chart, they only say very high.
Mm-hmm. Not high. So we should be looking in our report to see if there's any mention of fire zone. And if there isn't, would you recommend first we go to that website that is shown here, and also maybe call them and ask the geologist?
What I do is I tell people to go further down because they should be telling you if you're in a high, because normally they only say very high fire hazard severity zone.
Mm-hmm.
Some of them I've seen, and I can't even remember which ones, because Barbara, I look at everybody's.
I know.
But it's also if it's in the high, not just very high, and that's a big distinction. So you got to be wary of that. So all of this has been revamped and massaged to make it a little bit more clear as to what's going on with these, because I'll tell you what, when the first version of this came out, and the only people that I know that did not complain about it were attorneys. However, our main counsel that is on our calls found it very discerning that it was so difficult to read. And this is one of the reasons why they restructured this, because even the attorneys, we actually had attorneys on the same call disagreeing about how this was playing out. So that's why they changed this, to try to make it a little bit more clear for everybody, because it was giving everybody brain damage, to tell you the truth. Okay, now, interestingly enough, they had a second version of this on the website when I downloaded it. So I put it in here. I do not believe that this is going to be the one that they're going to release. I believe that they're going to be releasing this one, because the second one didn't look like it had enough done to it, but we'll have to see. But it's basically the same thing. Okay, the SIP, they have changed the SIP and they've updated it, because I don't know why, but people have issues trying to figure out what 29 days and 30 days mean. Okay, so the SIP again is if it's 29 days or less. If it's 30 days or more, you should be using the RLAS. And it's also telling people the buyer is advised to consult with a qualified local landlord attorney to discuss whether the possession could be interpreted as creating a landlord-tenant relationship between the buyer and seller if it exceeds 29 days. And this, a lot of people think, well, this is, no big deal. Yes, it is. It is a huge deal. Because if you have a landlord-tenant relationship, which the RLAS establishes, there are more requirements, there are more restrictions. And it changes everything, because a lot of lenders do not like that. They do not want you in a landlord-tenant relationship. Additionally, it can cause insurance issues. So even if you're doing an SIP, you want to make sure that you have your client, if you're representing the buyer, you want your client to call their insurance company and see if they need an umbrella policy for the period of time that the seller is in the unit.
Laura,
Yeah.
can you remind me if the seller is remaining in possession, whether it's 29 days or 30 or more, do they convert their insurance policy to a renter's policy, or do they keep it the way it is?
They should call their insurance company and check with the insurance company what their preference is.
Okay, thank you.
Long, did
I
you
knew
have a
that-
question?
I knew that
Yeah,
situation.
sorry. Yeah, just for clarification, are we specifically talking about rent backs?
Yep.
Okay, so anything after 29 days should be considered as a landlord-tenant relationship? Is it?
It's also a different form.
Oh, I see.
It's the RLIS if it's 30 days or more.
Okay, so this one is only for 29 days or less.
Correct. And that's what they're trying to remind people.
Gotcha.
And also, like it tells you in here that you need, if you're going to be going over 30 days, 30 days or more, then you might want to talk to an attorney just to make sure that you're not buying yourself trouble. And a lot of times it has, like cities like Berkeley and Oakland, they have all these little laws about rentals, and it's like a little quagmire. So, but you need to be very careful because like I said, once you establish a landlord-tenant situation, it's a different ballgame. It's not just a simple rent back. Now you're establishing a legal arrangement. It's a legal arrangement between the buyer and seller that you've gone from buyer seller to landlord tenant. Okay, and they put this in, this is added. Buyer may not move personal property into the property without prior written consent from the seller. We run into this all the time. I get these calls all the time. Well, we gave them a rent back. My buyer wants to move some stuff in. Can they go ahead and move it in? Well, the answer is very clear now. They have to have permission and consent from the seller before they start moving their stuff in while the seller's still there. So it took away the ambiguity.
Laura, what about the buyers, once it becomes a rental landlord situation, what about the buyers wanting to come in and measure and bring in contractors? I know, can they do that with 24-hour notice?
Yes.
Okay. And then who would pay for the gardening and landscape upkeep after it becomes a rental?
Well, that's part of the issue, which is spelled out on the RLAS.
Okay, thank you.
They've also revised the seller multiple counter offer. And the added language in here that addresses the situation where the seller wants to put one of the buyers as the backup. So it makes it much, much easier and much more clear because they've added this whole new section right here.
Well, that's really cool. Hey, Laura, I just want you to know how much we appreciate all the incredible information you provide to us and the value you bring to this office. It really is so appreciated and so timely, and you've done a lot of research. So I just want you to know how much you are appreciated.
Thank you,
for
Barbara.
sharing your knowledge and expertise and making sure that we're all up to date.
I appreciate that because it's one of my personal goals, just to get off track a little bit. One of my personal goals is to get us to the point that when people see contracts coming from our office, they know that they're dealing with a highly trained professional.
Mm-hmm.
Because I can tell you people, some of you are very new in the business, but Barbara and Allison can tell you, we run into people all the time that have been in this business for a long time. And we're stunned that they are not up to date. They're behind on everything and they don't understand the contracts, the new contracts. I mean, it's just mind-boggling. And I want people, when they see a contract coming in from our office, they know it's clean and it's concise and it's complete. So we are looked at as professionals of the highest degree. It's one of my things. Because I believe in you guys, and I believe in the education. And what I see from you guys, is that you ask more questions than a lot of people who just sit there and they don't ask questions because they don't want to know. And not knowing can be very costly. For instance, a lot of agents probably still do not know as of June 1st in Morgan Hill, when you do a point of sale, you have to have a sewer lateral certification. Now, the last agent who didn't know that out of the Palo Alto office, when she did a contract in Millbrae, she didn't have it done because she didn't know. and it cost her $25,000. That's a very expensive mistake. And if she had been keeping up on what the new changes are, that would not have happened. Okay, the SPQ, one of my favorite documents, has also changed. We kill a lot of paper. And again, the verbiage that was used in the commercial SPQ is also in the residential SPQ. And it says a yes answer is appropriate no matter how long ago the item being asked about happened or was documented otherwise, unless otherwise specified. A very good example. This is a real example. Vinicius was selling a house and he came over to me, he goes, well, it asks if there was a death in the last 3 years, but there wasn't. It was, like 15 years ago. I said, well, what was in his admin was standing behind him, and Neil goes, well, yeah, but it was a mass murder. Yes, that has to be disclosed.
So really, Laura, if somebody, because I thought the ruling was if somebody died more than 3 years ago in the house, that doesn't have to be disclosed. But you're saying if it was a murder or a suicide, that has to be disclosed?
Because
Even
that's
if it was
considered
15 years
a
ago?
material fact that can stigmatize the property.
So even if it was 15, 20 years ago?
Yep.
That has to be disclosed. Okay, what about AIDS? Remember years and years
Right here,
ago?
Barbara.
Hi, can you hear me?
Yeah, can you see
Hello?
this? It says, except for a death by HIV/AIDS.
Oh, it's so small on my phone. I can't
Oh.
see. Okay, thank you. I just wanted to make sure that was still the case.
Yeah. But in the logic behind it is that if there's something like a mass murder, that's not just a death on the property. That is something that can stigmatize the property, and a seller, a buyer, there were many people who would say, I don't even want to look at the house. And they have that right. And if you don't disclose that, because that's considered a material fact, not that just that there was a death on the property. It's a material fact that there was a mass murder on the property, and that stigmatizes the property. However, and here's the manner of death may be material fact to the buyer. And the thing is that you need to tell people, maybe it doesn't mean anything to you, but to a potential buyer, this could be significant. As an example, there's a big difference between somebody having a sudden heart attack and dying, and somebody dying of old age at the ripe old age of 98, who they just peacefully died. That's a difference. Because some people would look at it and say, oh, this house was blessed with somebody who lived here for 98 years and passed away peacefully. But if somebody had a heart attack or they had lung cancer or something like that, that they may not feel that same way. So it's, so you need to give the information, and they need to be honest about it.
So in those two cases, you have to legally disclose to the buyers regardless.
If there was a mass murder, you betcha.
Oh, of course. Yeah. If people died of natural causes or like a heart disease after 3 years, do you still like
This is within the last 3 years.
Okay.
But if there's something significant, it doesn't matter how long ago it was.
Gotcha.
Okay, and they've added in here, plumbing fixtures, non-compliant. In the material facts or defects affecting the property not otherwise disclosed to the buyer. Another material fact could be, let's see. Oh, another material fact not disclosed could be that, and this actually happened to me. We had to, when I sold my house, we had to disclose that the adult child living across the street. He's a schizophrenic. And at one time got a hold of a weapon, and we had the SWAT team out to protect everybody. We had to actually evacuate our home over the back fence. And he was now, there was now a court order for him not to be allowed back into the neighborhood. That is a material fact. That is something that we have to share. And fortunately, my next door neighbor moved before we sold, because the next door neighbor, the husband, had Tourette's syndrome. Are all of you familiar with what that is?
No.
Yes,
Tourette's-
yes,
Pardon?
yes, it's a neurological disorder where they have trouble speaking coherently, and they just speak out without any warning what's going
Right.
on.
And a lot of times it's very foul language.
Mhm.
And they could be standing in their driveway washing their car, and all of a sudden this string of profanity starts coming out of their mouth. Well, a lot of people, if they had small children or, were sensitive to this, they wouldn't want that's a material fact, because they wouldn't buy the house. It affects the value of the property in their eyes.
Laura,
how much
question?
did- Oh, sorry. Go ahead,
Yeah,
Ryan.
Ryan.
Would that sort of thing impact an appraisal, knowing that a neighbor has some severe Tourette's, even though that's protected for being kind of a medical thing, I would assume.
I don't know. I don't know how to answer that.
Okay.
Okay. Okay. Oh, we're running out of time. Jeez. Okay. They made this a little bit easier to fill out. Was the property built before 1978? Of course, this is the lead paint issue. And if no, leave A and B blank. I love that. Okay. Also, disaster relief. It asks you specific questions about disaster relief. If yes, was federal flood disaster assistance conditional upon obtaining and maintaining flood insurance? Yes or no? Right, and see in here, so they've added a few more things for clarity. Condominiums, ugh, the bane of my existence. Whether the property is a condominium or located, yes or no? Any HOA has authority over the property, so this needs to be read carefully. And they're asking specifically CC&Rs or other deed restrictions obligating the operating association, the committee that has, because most larger HOAs have an architectural committee. So if you want to do something to your house, you have to say, Mother, may I? Okay, so this makes it more clear. And remind you, if you're representing the buyer, you want to read, don't just necessarily take this for granted, because a lot of sellers don't know. You want to read those CC&Rs. That's
Laura,
your,
I have a question for you.
Yeah.
I haven't sold my listing yet. It's a condo. Are these forms already out? We need to update.
June
Do I need
20th.
to read? I'm sorry?
June 20th, and if you've already filled out forms, then you don't have to update.
Okay, that was my question.
Okay, and again, features and this is just more for more clarity. It makes it more clear. Asking about features of the property that are shared. The thing I like is that as time goes on, they add clarity to it. Instead of making it like, well, does it mean this or does it mean that? And believe me, with HOA docs, it's a world of difference. Past or present disputes or issues with a neighbor which might impact the use, development, or enjoyment of the property. Well, if you have a neighbor who is a grumpy old man and just screams and yells at everybody, yeah, you got to disclose that now. It's even if, and a lot of times In fact, I think it was you, Barbara, that wasn't you that, or somebody else that the neighbor, the seller had a dispute with the neighbor. Yeah, they didn't like each other and kind of went out of their way to make each other miserable. That had, you know, in this one now, they have to disclose it. Just so they're aware. Tenant occupied property, when you are transferring property where there's a tenant, for the purpose of the tenant property addendum. And they've updated this, say, if seller is remaining after the close of escrow, tenants shall be removed by the time specified above. Okay, they've also updated the government compliance. And they're talking about, you know, if it's vacant or not vacant. So, you know, make sure you read this carefully. And that's it, because there is one more form that was updated, which was the wildfire disaster advisory, which kind of goes hand in hand with the fire advisory, but they didn't have a copy of it available yet. So I guess they're still working on it.
What was that form, Laura?
That's the wildfire disaster advisory.
How is that, what is that specifically about? If you're in a wildfire area on the
Yeah, well, what they did is
NHC,
they added they took language out of the FHDC, the fire hazard disclosure, and put that into the wildfire disaster advisory.
So that's a new form?
It's a revised form.
Okay, okay. I have a couple of questions, just real quick.
Yeah.
My client is in contract with New Homes. I've never seen the contract. It was never sent to me.
Well, you need to call them and ask it.
Yeah, so I don't know what all she signed. And also about compliance issues, low flow toilets, things like that, low flow shower heads. These are not point of sale requirements still, correct?
Yes.
So we do not have to do that. And another question.
Check the city ordinances.
Oh, check city ordinances. And then the last question I have is about compliance with you know, with heating and air conditioning, the vents and that kind of thing, the duct work. Can you refresh my memory on what's required with that?
I don't know. I don't know of any requirements.
There's something, it's not, I don't think it's a point of sale requirement, but when you update your furnace, whatever, it has to be brought up to.
Well, that has to be done with permits.
Yeah, there was something about the ductwork. I'll look it up and talk to you about later.
Any other questions, guys? I know this can be very dull and boring. So I try to make it nicer for you. And all of you have copies. Besides Barbara, does anybody else not have copies of this, of the material? Everybody has it? Yes, no?
Yes.
Okay.
Yeah.
Laura, I have a question.
Yes.
Do we have a list of cities that require a sewer lateral certification?
I would check with your title company. They might have one. We in-house do not.
Okay.
Most of the cities from San Mateo up,
Mm-hmm.
yes, it's San Mateo. I'm trying to remember who's first, Millbury or San Mateo. Because Burlingame, San Mateo, South San Francisco, San Bruno, like around there. Morgan Hill now has it. Eventually it's going to be statewide.
Okay.
That's where it's moving to. And again, I want to remind you guys to start studying the buyer representation agreement, because we as in CAR is working on a new form. The rumor I heard is that they're trying to make it a one-pager, and it is going to become required when you work with a buyer. So
When is it
that-
taking place?
we don't know when they're going to start when they're going to make it required, but it's coming down the pike. So you might as well get used to doing it now
Yeah.
and learning how learn your scripts around that, why somebody should be signing it. Because in actuality, it really protects the buyer, because it explains to the buyer, it tells them what to expect out of you, and what your responsibilities are. And I, like I said, we have not seen the new one, but there is one coming out. Maybe in December, because they do releases in June and December. So hopefully by December, they'll have that done. And if it's a one pager, yay, because that's much easier. And it's for one pager would probably be easier to explain than the multi-page like we have now. But you guys I really want you guys to start getting used to that and using buyer representation agreements and learning how to explain that, learn your scripts around that, because that's going to be, it's like I said, it's coming down the pike that it is going to become required. So get used to it. And when you can, try to bone up on sewer lateral. In fact, I think I might have a link to a class that was taught to SCORE. I'll have to look for that, because SCORE recently did a class on that. What is sewer lateral? So you can kind of understand what it is. So knowledge is power. That's the way I look at it. And the more you're up to date, the better off you're going to be, and the less likely you are to get in trouble. That's what we want to do, is to protect you. Any other questions before we close up?
Laura, can you also send a copy of this document to me as well?
Yep. Let me write that
Thank you.
down.
Laura, this is
Yeah.
Allison. Can you send me too? I'm not sure if this one is the same one that was sent. Can you send one? Yeah.
Yep. So I've got
Thanks.
Long, Allison, and Barb. Anybody
you.
else? I really appreciate you guys coming to this. That makes me feel good that people are still interested in staying up on top. Because this gives you the advantage, because you're in conversations, when you're talking to other agents or even your clients, you can say, well, that we're coming out with new forms that's going to be changing, so it just makes you look like you're more informed, which you are.
It protects us too.
Pardon?
It protects us too.
Yes, it does. You guys are going to be the best educated people in the planet. Like I said, that's my personal goal, to raise the bar on professionalism.
Thanks to Laura.
Oh, no, not just me. But, in fact, one of the classes that we're working on getting somebody to do it is at SCORE, is having a class on professional conduct and etiquette, which is also ethics. Because I haven't had it happen in this office, but I have had to deal with agents. I am appalled by their behavior. Because if some of these people acted that way and they were in this office, they would not be in this office anymore. Their behavior was just so outrageous. And I'm happy to say that we rarely have something like that happen in this office. Yay, good for you guys. That says a lot about you.
Tempted to ask what happened.
It was after the close of escrow, and the buyer's agent, it was a zero contingency, and the buyer's agent, they did not do inspections, and at their choice, because it was zero contingency, and did not do a verification of property, and the buyer's agent was sending threats to they're going to take everybody to small claims court, and all kinds of outrageous things. And I actually ended up sending an email to the regional vice president of Sotheby's, because the behavior was so outrageous. She didn't do her job. And she was trying to offload her responsibility onto the seller and our agent. And I will not tolerate that.
Well,
Yeah, and the VP of the regional vice president of Sotheby's is also an attorney. And he did talk to the agent, and then she sent our agent another email, kind of backing off a little bit, but her last sentence says, "See you in court." She can't, and so I sent that off to the VP and said, he had to have a discussion with his agent. And this is a lesson for you guys, because I told him, he said, you need to have a discussion with your agent about the terms extortion and malicious prosecution. She did not do her job, and that is her issue and not ours. Yeah, I just will not tolerate anybody treating anybody in this office like that. I mean, and I heard a phone conversation, and it was just unbelievable. So kudos to you guys, because I've never had anybody call me and complain about your behavior. Proud of you guys.
Thank you, Laura.
Okay,
Thank
any
you
more
so much,
questions?
Laura.
Thank you
Thank
so
you.
much, Laura.
Appreciate it.
Okay, have a good day.
You
You
too.
too.
Bye-bye.
Bye.